Frank, can you hear me?
Yes, I can. Thank you.
So you are vice chair, and since Casey is gone, are you
I was wondering if Sherry, if you want to, or one of you guys on the board want to take care of it.
run the meeting from here? Yeah, someone here can do it. I just wanted to
Yes.
verify that was okay with you.
Yep, no, that's fine with me. Patrick just got done showing cattle, so we are in Sioux Falls yet.
Okay. And is Frank the only one on? And Dylan's on too. Okay.
Yep, I'm here.
All right. Well, it is 7 o'clock. We probably should call the meeting to order. Does anyone else want to run the meeting? All right, I will take it. All right, time being 7 o'clock, we'll call the meeting to order. Roll call, please. Would everybody turn your microphones on too? It's the little speaker button.
I wanted to introduce myself because some of you may not know me. I'm Bill Conkling. I'm the new deputy zoning administrator. It's nice to meet you. Grant.
Here.
Krolichek.
Here.
Kirschman.
Here.
Hanson.
Here.
Bixler. Loest.
Here.
Healy.
Here.
Tacky.
Here.
And Cruz is gone.
All right, items to be added to the agenda. Does anyone have any additions to the agenda? There being none, I would entertain a motion to approve the agenda.
So moved.
And a second.
I'll second.
So I have a motion and a second to approve the agenda. All in favor, say aye. Aye.
Aye.
All opposed, nay. Motion carries. You two on the Zoom or phone, when you vote, if you would give your last name so we know which of you are voting there, that'd be good.
Krolichek was the one.
Yeah,
First one.
it's more important when we get to actually voting on the applications itself, not necessarily
Okay.
the agendas. So just to make a request there. Approval of previous meeting minutes. Are there any amendments to the minutes? I would entertain a motion to approve the minutes.
Hanson, motion to approve.
So I have a motion by Hanson. Do I have a second?
I'll second.
I have a second by Healy to approve the minutes. Any discussion on that? All in favor, say aye.
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 All opposed, nay. Motion carries. Minutes are approved. Okay. Do we have anyone here who has a conflict? Anyone want to recuse themselves from one of the two applications before us? All right, there being none. Yes, sir. Okay, so for those at home or listening online, there has been a request for Mr. Healy to recuse himself from the Gunderson, the JHGAS Farms application because of past history. And Mr. Healy is listed as one of the easements. So I will bring this to the commissioners to comment on whether we feel he needs to be removed or not.
Which easement are we talking about? And how How does that affect the outlet where you went with the wedding? Do you have that easement with you?
Here's the whole lawsuit. Which do you want? The engineering report, the judgment approving the stipulation from the judge signing, the whole lawsuit, notice of entry?
The easement that would affect this application.
Part of the, David J. Healy and Margaret J. Healy, plaintiff versus John Gunderson and chief and defendants. Here's the whole brief.
The easement, please.
It's part of the brief. It's 28 pages long. Would you like to see it?
Are we talking about an easement or are we talking about a brief?
Sherry, can you have the person in the background talking? I can hear Healy, but the other people talking.
Yep. Mr. Gunderson, would you come to them? Yep, Frank, just a second.
Apologize for that, Mr. Kralchuk. Mr. Healy's been, and his family have been in 2 direct and 1 indirect lawsuit against us in the last 10 years. Really has a very clear conflict of interest. And again, for Mr. Barkle and Mr. Kralchuk, we have a court-ordered easement and stipulation which is included as part of permit 20-015, which allows us to drain water into a tile that Mr. Healy installed on our property. And I really don't think it's appropriate for these reasons for Mr. Healy to be part of the discussions or any vote on our permit.
Are you draining water into that line?
Doesn't matter.
Well, I think it does.
Not,
That line has nothing to do
Mr.
with
Healy,
your
you're
project.
obviously biased and rather litigious about this. And your presence in these deliberations would be a clear example of bias.
I guess I don't agree with that. How many people did you contact before this meeting? Personally contact?
I don't remember.
You have contacted members on the board.
I have
Prior
talked
to
to
the
a couple
meeting.
members on the board. I don't remember everybody I've talked to.
Do you think that is appropriate? And don't you think those people
Well,
should be
tell you
recused as well?
what we can do. The state's attorney is willing to come down and talk to us about it. And if you'd like to invite him down, I'd welcome him down.
If that's necessary, then I suppose we should do that.
Well, then I'll leave that up to the commission to decide whether they want to invite him.
So at this point, again, I'll bring it back to the commissioners. Do we feel there is a need to have Mr. Healy recuse himself?
I did find the judgment approving stipulation creating easement requiring compliance. Signed by clerk of courts, stamp on February of 14.
Give me a little more information on exactly how this project affects the line that runs across the
Mr.
border
Healy, I've
that you're not
repeated it.
draining water to.
I have repeated it
It's
3 times.
not
You are-
connected to that line, so there's no correlation there. There's no association with that whatsoever. I think you're trying to cloud the issue.
Mr. Healy, you have shown a clear negative attitude towards us and the things we want to do.
I think
I
it's been
really think
mutual,
that it would be
Mr.
grossly
Gunderson.
inappropriate for you to be part of this.
Are these 2 easements the same easements we're talking about, or are we talking about 2 different easements? I'll ask the
There are-
question.
Mr. Grant, I'm happy to answer your question. There are multiple easements involved in this. There are easements between Mr. Healy and us. There's easements between easements plural between Linksteads and us. it would be, again, he's voting on a permit of which he has easements. The water, I agree, is going another direction, but he is still listed as part of the permit application, and therefore should be disqualified from discussing this.
That's not any reason whatsoever. It's mute. It's insignificant. My name is not on any of these easements.
So you're saying you're not bound by the easement from the judge?
I have no name on any easements in front of us here.
So you're denying that an easement exists across?
No, I'm not denying that. I'm saying that the easements that we have here in front of us have nothing to do with me.
Okay,
Well,
so at this time, I think you two are going to go back and forth.
yes.
So we need to bring it back to the other commissioners to make the decision of whether Mr. Healy needs to recuse himself from this application.
I still go back to the same question I had before. Is the easement or the application that we're discussing tonight have to do with Mr. Healy?
My understanding is Mr. Healy did not have to sign any easement for this specific project, but there is an easement with other land in the area.
So the answer is no.
There is,
That is correct.
I'm not asking John the question. You brought it back to the commission, so can we have our discussion? The question was, is this project that's being presented in front of us, have Mr. Healy attached to this project or not?
so,
No, it does not. I do not.
so
That's my question.
there is no easement signed by Mr. Healy in this packet.
He is listed
He is listed.
on as parcels that are connected to it.
Okay,
That's my only question.
okay.
That's supposedly
that
being
you got
notified.
letters.
I was supposed to be notified even though it wasn't. That's the only.
Right, these are notification letters.
This is Frank here,
Yep.
and I don't know. I think that was Kevin just speaking up that he was one notified, and Kevin and me. Correct me if I'm wrong, Kevin. In the past, when we're directly involved with something or something that is part of, a neighbor project that we got noticed, or if we're tied to the land somehow, we've always eased ourselves from the position. But I don't know, correct me if I'm wrong or not, if we gave notice and say my neighbor is tiling, gave me notice, I have sat on the commission. For example, Sternhagen's beside me. So my concern is if there's an easement tied to this is one thing, but notification should not disqualify him.
So your opinion, Frank, is
Yeah, if there is water draining on or any type of this project is connected somehow, if there's an easement or something, I'd say he should step aside and speak during comments. But a notification to him, for example, say Dave and Nick Sternhagen, just the next section beside me, did some tiling. They gave me notice. Then that shouldn't. I stayed on the commission at that time because I did not directly dumping water in their tile, but they did give me notice. But I'm saying if there is an easement, I'd say you'd have to step off. Notification, I do not think should be disqualification,
okay.
if that made sense.
Yeah. Greg?
Frank said makes sense. You know, but I do know from previous here that there's been history, so I don't know where you go with it, you know? I don't know.
Kevin?
I'll say one other thing here real quick. When I was on the corn council, when in doubt, you always stepped off. You know, if it was going to have problems, you know, down the road, as a board member, if you do see problems, it was always advised through training and everything to step aside if there's enough people to make a quorum. So if that's where we're going, Craig.
Do you have any thoughts?
Yeah, my personal opinion is, since there is a history and no matter how the vote turns out, if David is part of the vote, then it can become a part of contention down the road. If he recuses himself, then that wouldn't be an issue with the vote one way or the other.
Okay. Any other thoughts?
Well, if that's the mindset we're gonna do, then I'd have to recuse myself because John and I have had disagreements in the past too.
But are you directly related to this project?
That's not where your point was. Your point was if there's a disagreement, then down the road, we could have issues. John and I get along great now, but we've had our disagreements. We're in a small area, small community. People are gonna disagree. It goes back to the direct, is he directly involved in the application process of what's put in front of us? Is he directly related to? If you show me an easement that he is, show it to me. That's all I ask. I don't see an easement in front of me that shows me that.
Okay.
Mr. Grant, I have no problem with you being on here. We have had disagreements in the past, and you may decide that I'm crazier than a raccoon. That's fine. But you and I haven't been in repeated lawsuits over the years. Your name is not part of this. And therefore, we may disagree, but you have more than earned your seat at the table.
I was just countering his point. That's all I was doing.
Mr. Tacky, do you have any comments?
You know, I don't. I guess I've never been a part of this. I just feel like there is tension there between both parties. So I guess, you know, if I was in the shoes, I would maybe step away, but that's just how I feel. I guess I've never been a part of this. This is my first time experiencing one of these. So obviously there's going to be some conflict of interest, I feel, just in a little bit of talks we've had here tonight.
Thank you. So at this point, probably the best way to do it is to do a vote.
Is it possible that I participate and not vote?
I think that would be tough.
I would like to participate in the discussion.
I think this is Frank here, Sherry. I think if he, I'm just speaking out for both of you. Even if he sends his vote or either way, if there's times for both parties to talk. There's, when we get the application going here, Gunderson will explain it, and then there'll be public comment against or back and forth. And I think we're open to the idea of listening to comments back and forth, aren't we?
It might be an even compromise. Just can't vote. Would the rest of the commission be okay with Mr. Healy participating and just simply not voting?
Abstaining his vote is what you're saying.
Yep.
I'm going to say I'm all right with that. Or if you really want to make it clean, you just, and to participate as a crowd. But I guess I'm all right either way. That's Krolichek.
Thank you. Any other comments?
This is tacky. I think at least being on the commission, he should have a right to state his opinion on what he feels. If he can't vote.
Kevin?
We've had it in the past where people have taken part of the discussions and then abstained from the vote.
Okay.
So I would be okay with that.
Is that the general consensus then? Mr. Healy can participate, just not vote? Anybody against that? All right, we will proceed that way then. So there is a conflict recognized. Vote will not be made on Mr. Healy's part for the first hearing, which we are at, and it is 7:20. So it is time for the JHGAS Farms LLC application. Mr. Gunderson, please come forward and explain your application history.
Good evening again.
We created packets for the commissioners.
This is Ann Schiefen,
I'm the other half of JHDS Farms.
GAS part.
Does David get one?
Yes.
Okay. Are we ready?
Yes.
The past is a prologue, and it seems that history always repeats itself. 35 or 40 years ago, we wanted to drive the corridor that we call the Great Swamp, and the downstream landowner was worried about his stock dam. To avoid a fight with that landowner, we went around. And that's why the ditch on the west side of 443 is so deep, and I'll get some pictures in a minute. After we were done, the downstream landowner, Clifford Courier, worried that he wouldn't have enough water for his stock dam. Well, the road to hell is paved with good intentions. You might want to write that down. I should have. Here we are. We had a valid permit, number 20015, based on land history. We were draining from us to us. This quarter, my family started draining in the 1960s. We surveyed it and did further ditching in 1985 and more surface ditches in 1990. Easements exist between Linkstead's, when we're talking about this current year project, between Larry and Christie, that we signed in 2013. In 2013, we did phase 1, which is permit number 75. We've been planning and working on this since that to do the next phase. And it depended on the yield maps. We submitted the plans, got the township agreements in place, got the design pretty well organized, the area to be drained, the size of the outlet. We bought the tile, we purchased valves. And here is the what we're doing. This is the ground, the north, the top of the from the north. There's a little stock dam up there. And what you can just see on the south of that is the start of Larry and Christie's stock dam, right down there. There's ours. And the proposed outlet, we're actually going to go into this ditch, somewhere in that area. This picture, let me go back one. Taken, that's what you, obviously, clearly front waterway. This is what it looks like. North side of the road. Here's the intersection, and we had another set of pictures that we lost. So we ended up unfortunately taking pictures after we had the snow and the ditch full of snow. But the ditch is about 5 feet deep in here. The thing that makes this interesting is there's a 3-phase power line buried under the road there. This is the same ditch looking to the north. And then from where the previous picture was taken looking to the south, it's pretty flat, but it gets pretty deep in there. And again, because of the snow, you can't see, but there's an erosion issue. It was not probably the best place to put constantly running water. Some of those erosion spots are 3 or 4 feet deep. And this is what it looks like down through that culvert. This is where the outlets, where there's a standing on top of what's a 4-foot culvert, and what we call mountain cedar trees that go horse in. I'm on the north side of 299, standing in the culvert with my elbow sitting on top of the 4-foot culvert. This is where the water is actually going. This is where the water ends up and is bottling down there. Nice gray sweatshirt. And water goes under the road there, back in the mountain depth, opening up the hill. And this is actual green outlet right up there. And what we originally had planned was bring down and that's what we did. We changed at the last minute. We changed because we had a better location. Again, we did not change the outlet size. There was a small reduction in the watershed. We did change the outlet location. We wanted to move because we could move upstream. Instead of going down a ditch with the inherent problems of erosion, we could go through these culverts that are on 299 and 443 that are already rocked up. We didn't have to fight the driveways. We didn't have to fight the underground power line. We didn't have to cross the road. We're going in a better location. The culvert, actually, if you look in the floodplain map, not the blue line map, the floodplain map goes just about up to that culvert on 299. There is a blue line in this project, but it's in the middle of the stock dam. We have a natural waterway that doesn't have a blue line. I realize we got our permit in August of 2020. We've been waiting several years to do that. It took a while to get our contractors there. We got the tile delivered, we got the equipment on site, we got the crew on site. The weather was good. It was the 4th of December on a Friday, and then we had to change plans. And we notified the county that we were moving our outlet. We worked on Friday, Saturday, Sunday, and Monday. And on Monday, we got a notification that there was an issue about how we had done the permit. That was after the tile was in the ground. So what are you going to do? There's a valve installed on this tile. It was installed and it was closed. So the tile was installed, and out of courtesy to the ordinance in this board, we closed it. I'd like to briefly go through some things in the ordinance. If we go to section 103, one of the purposes of the ordinance is to prevent inordinate adverse effects on servient properties. Now, basically, going where we are, we've essentially eliminated erosion. Both those culverts are well rocked, and they're in a well-defined waterway. If we go to section 201, pardon my slowness here. We go to section 201. It talks about definition and a benefited area. And it's a direct benefit to run down a creek instead of down a ditch. We've had this issue many times before. We're not going to have the erosion issues. We're down into an established water course. It is not a blue line, I admit. But it is an established water course. This is important. We'll come back to that in a moment. We've done a modification. We did not do a new project. We did not do this without a permit, but we did modify what we were planning on doing. We ran water into a natural water course with easements. We have vested drainage rights on this property, filed and recorded in 1991, both with the county and the state and NRCS. In 2014, we were in the process and did a wetland inventory on the farm ground. There are no wetlands other than that stock dam in this farm ground. So then we get down to, oops, I lost the page. There we go. Section 303. Now, section 303 allows you to move an outlet, and it sets a metric for that moving that outlet. And it's the 10% rule. We are within that 10% rule. Now, I'm pretty sure there's a question of, how you do this, but again, we did not change the outlet size. We did not change watersheds. We actually are making sure the water is remaining in the entirety of the watershed for which God put it. Now, section 305 grants authority to grant or deny and essentially change a permit as you're needed. And 305.1 talks about draining into a blue line. But 305.2, which outlets directly into a permanent or intermittent stream not listed in number 1. In other words, it was not a blue line. And it is a natural drain, which obviously this is. And you have easements. And if no abutting landowner files a written objection within 10 days, it is a permitted modification. To our knowledge, no objection was filed. I made assumptions based on my reading and experience of the drainage ordinance that we could change this outlet location. We did notification. Linksters were aware of what we were doing. Questions were asked after we did the installation. As an act of good faith, because of those questions, we closed the valve. If you have any questions, please feel free.
John, this is Frank here. Thank you, Sherry, for sending me the picture of that map. So your outlet drains and then goes to the blue line, correct? Or is it in the blue line where the outlet is? Explain that to me one more time.
The outlet is not in the blue line. It's about, Larry, what are you guessing about? Yeah, it,
It's crossing through the culvert into my
yeah.
side, and it's in the blue line.
The blue line is actually in the middle of the stock dam.
Okay,
And
but you have easement to get to the blue line?
yes,
Okay. Because I was just making sure that you change your outlet, that you still have easements to get to the blue line.
correct. We
Okay.
changed, we changed the location of the outlet, not the size of the outlet. We just changed the location. So instead of bypassing the stock dam, we're now going into it.
Okay.
Any other questions for Mr. Gunderson?
So on that map that you have up here,
Yes,
the red and the green, which one's it? Which one is actually done?
the green,
So the green is what you did.
what we did.
Proposal was to bring it over.
The proposal was the red.
So
on the other
was
side
the
of road.
previous permit pipe all the way over through the roads to the ditch, or was it?
The other permit goes into the same stock dam outlet on that file, permit number 45, enters in just the other side of the creek from where the outlet is now. And it basically takes the south half of my quarter and Larry's quarter and dumps into that same place. The reason that it's down there is we irrigate this quarter and we go out past the end of the end gun or the last tower. So I'm not walking pivot through water.
The red line was what you was originally intended
Right.
to do.
That's what we intended.
So
to
is
do.
that where, I think what your question is, Kevin, is that where you were going to dump water in the ditch, or were you going to run that red line clear down to the blue line?
If we could get it down to, if we could get enough fall in that ditch, we were actually going to, where that red line ended, is where we're going to end the pipe.
That's what the previous permit was.
Right.
Okay.
That's what the original
I had
permit
approved
was,
or-
yes.
Okay.
Because that ditch, what we did back 35 years ago was take roughly 60 or 70 acres off that quarter that ran into the stock dam and took it off the stock dam and ran it down the road ditch. And we get a 5-inch rain, it still goes that way. There's a lot of work that's been done in that corner. In the pasture here, there's a hand dug channel that runs down like this that predates that road. Because nobody in the last 100 years has been that ambitious.
Any other questions for Mr. Gunderson before public comment?
Oh, why didn't you choose option A?
You mean going straight west?
Yeah, I see an option A.
It
Well,
was a question of cost. Pure cost. Instead of having to buy another quarter mile of 12-inch pipe, we could have gone that way. But Wally and Corey came in and we resurveyed that ditch and we determined we could get enough water down it. Very simple. It's a matter of economics.
how come this didn't come to the board? Typically, anytime we cross the right of way, it comes to the board.
I agree. And again, this was a last minute change. And
Are you talking about the
I'm
original
talking about
plan?
the original.
The original plan?
Application should have come to the board.
the original was, it was granted because I was granting from me to me and we had existing easements.
We've had that issue in the past and it's always come to the board.
Then you should probably talk to Mr. Vetter.
you're aware that in the past we have done that.
More than aware. But the permit was issued the way it was.
Okay, so even though
And
you
I'm
were aware
assuming-
that we normally would come to the board,
I am
you
assuming
bypass that step.
that Mr. Vetter was using section 305.2, which does grant him the authority to do what he did.
When you proposed to go to the new location, did you go back to Mr. Vetter then?
I did not. I worked through the state's attorney, and I talked to Commissioner Lowe's at the state's attorney's suggestion.
That's been unprecedented. Why did you not go back to Mr. Vetter?
Because of pending and past pending litigation in the county, I worked through the county enforcement officer.
County enforcement officer. And that would be,
Mr. Clemish. If you want to speak to
State's
Mr.
Attorney
he's a
Clemish.
state's attorney, yes, yes. I don't know where the ordinance gives him any authority to grant that permission.
Are we in public comment, or is Mr. Healy still sitting at the table?
And part of the discussion, I'm asking questions, I guess, trying to get.
The board okayed him to be part of the discussion, just not the
Okay.
vote.
It was determined with discussion with Mr. Clemish that this would be the best way to proceed in this situation.
Even though that had never been done in the past.
There's a lot of things that haven't been done in the past. This was one of them.
So who actually gave the permission to move the outlet?
So there is email correspondence that I sent to Mr. Gunderson after our phone call and after I looked at his change in the plan. And I don't know if you've read that in the packet.
I've seen it, yeah.
Yep, so looking at it and reading, and I know there's number 2, I read number 2 as he needed to come before the board now. Since it was,
I read too. Right.
but having been the first, technically he was draining onto himself. And in the past, my history has been, and that was before I got involved, the original permit was issued, that he was draining on himself, so he was okay. That he did, and I know we have issued permits in the past where that has been the case. And I know we've issued permits in the past where it hasn't been the case.
No, I can't say where we have. Only time you can only drain on yourself would be into a blue line.
Generally, if it involved different parcels and it required, even if the parcels are owned by different same people. But I don't know what the parcel numbers, I didn't look at that.
The parcel numbers are separate.
So if you cross parcels,
Okay, that,
whether that's right or wrong, but that's what. we've
and
done-
that was
had done
before
in the
I got
past.
involved.
Okay.
That was the original permit because it was John's land and John's land and he was going to the blue string
And,
In
and,
the
again-
That was
original
in the
proposal.
original proposal.
Yes.
Yes.
and again, I am here cheerfully. I mean, I have no problem with the questions being raised. And if we've got to go through the process, there was no attempt to hide anything here. No attempt at any sort of subterfuge. And again, we put it in and close the valve until we get this ironed out.
But there is an easement in place from the stock dam coming south
Yes,
to the blue line
yes,
at this time. Or
yes.
that was done since,
It was done in 2013.
that's from the original. Okay.
How come that wasn't part of the original proposal?
Which, you mean permit
Well, you have
45? or-
option A, you have option B, and then you chose option C.
There was an issue of water in the stock dam. And rather than fight with Larry and Christie about it, I went around. And we get ready to put the tile in, and we had a meeting in the mines, and then we didn't. It's very simple. And had it not been the 4th of December, probably I would have come to the board. But on the 4th of December, when you have something like this, we tried to get it cleared. We thought we had it done. Obviously, we didn't. There are questions raised, and we're here. Happy to answer questions. It's not that complicated.
I guess I'm still not sure why this didn't come to the board. It should have come to the board. The original proposal, the second change, all of this should have come to the board. I'm not sure why.
That would have been the decision of the zoning administrator at the time.
Right.
I mean, as far as the board, that.
Yep.
I mean, that's.
That is correct. And my understanding also is like Sherry's. I don't, obviously I'm new and didn't know the history of what may or may not have occurred in the past, but my interpretation is just like John said, if it was going out on his land, to his land, I didn't see that would have been an issue personally.
Well, I see no notification letter in the packets, and I don't see the affidavit where you sent the notifications out.
When we're, again, you raise a valid point. We didn't send the letters out because we were going from me and to me. If there'd been an issue, and those of you who have been on the board for a long time know that I've always stressed contacting the upstream landowners if there's an issue of them needing access to a tile. But Mr. Healy's water goes the other way. And the only person involved are the Linksteds. I talked to both Schramm's and Cease's. They had no problem. They're the downstream ones. Again, we were going from me to me.
So no notification letters went out.
No notification letters went out. If we have to send out notification letters, happy to do it. This is not, I don't view this as adversarial. I strongly support.
I have a,
And this is not adversarial on my part. I want to get clarification so that we don't have issues. And if we've got to send out notifications and come back in a month, happy to do it.
Frank, did you have a comment?
yeah, I do have a quick question. The blue line is on John Jennerson's ground. Is that correct?
Well, yes and no.
It's no.
If,
There's no yes or no.
Frank,
I gave him permission to put it on mine.
The blue line is on your property there.
Yeah.
It is not on Mr. Gunnarson's.
Yeah. Where the drain is going to end up going, the water is on Mr. Linksted's property.
Okay.
That is where the blue line is at.
Frank, if you think of a checkerboard with A, B, C, and D, Linksteds are A, we're B, Linksteds are C, and we're D. The original application was going from B to D, and when it got to the D, it was going to be in the blue line. When we changed, it went from B to C, and the blue line is on Linksteds.
On the original application, the blue line was on yours or on Linksted's?
On ours.
Okay. So I know in the past, there's been situations when we first started doing this, it'd be, say my dad bought an 80, then bought another 80 from his sister, and then it's both my dads, but he had to get easements from himself to himself, but the blue line was still on his ground. And that never came to us till about, Kevin Healy, you'll have to clarify, but that was about what, around that 16, 15, 16, 17 time frame when Pat started bringing some that he had questions about. But before that, I think Pat Garrity was permitting them always before that. Because I know I have an application in the file that has it like that.
Well, I think we need to clarify, the blue line is not on the Gunderson property.
For the change, it is not.
For the change, it is not. For the original application, it was, whether it was option A or option B, it would have been into our own blue line. But when we changed, it went into Linkstead's.
And it goes from Langsted and C, blue line, into our blue line.
To get to the blue line on option A, you had to cross under the road.
Correct.
Under the right of way. Which
Under
should
the
have
right
brought
of
it to the
Right.
board. Option B, run it down into a ditch before it gets to the blue line. There again, should have brought the application to the board. The blue line is not on the property that you drain to.
Blue line is in section 16, where the water would have been drained into.
Correct. And you put the tile in section,
We started in 10, we would have gone to 16,
yeah,
and we ended up in 15.
and it did not drain to a blue line.
Did not drain into a blue line on 10 because the original application, it would have gone to 16.
There's not a blue line on 10 as well. It didn't go to
There
10.
is not a blue line, but there is a natural waterway,
And an easement.
and we had easements in place.
On your first, during the original application, you crossed the road
I would have had to cross the road.
and did the township road?
Township road they had no problem.
Did they do a written?
Yes.
Easement for that?
And we had.
Okay.
I mean, again, had it not been the 4th of December, I probably would have said, let's stop. But 4th of December, expediency is not a good excuse, but and I thought we had it cleared up. I thought we had the necessary clearances to go. And again, the questions were raised after we had the tile in. And again, I put a valve on it and it shut the valve.
But John, if you don't mind, dealing with what we're looking at now, the only thing you seem to be missing would be the letters going out.
Pretty much.
Everything else
Yeah.
is passed. We can sit here and debate about it all night if we want to. It ain't gonna get us anywhere. It seems like, to me, the only thing you're missing are the letters.
And I'm happy, if we have to send the letters out, happy to do it and happy to come back in a month and I just, if you saw how big this creek was, you realize how little water we're really talking about. And it's,
If that's the only thing left to really dot the I and cross the T, I don't see why that would be an issue, as you're saying.
okay.
That's my opinion.
Yeah, again, I do not view this as adversarial. This is a situation of our own creation and we're willing to deal with it.
I'm going to ask for public comment now. Would anybody in the audience like to make a public comment on this application? There being no takers. Oh, well, there being no interest in public comment is closed for the application. We'll bring it back to the commissioners. Dan has expressed that we need to get the notification letters sent out now. To further talk about that in our ordinance, we have said if at times when if there's no feedback from those letters and notification, there's no need for an additional hearing. So I guess we have to consider if that is our concern, we need to get notification letters out to, is it a half mile up, a mile down? Is that how it goes? If we send those letters out and there's no feedback from those letters, would this application actually have to come back before the commission for final approval? Or can we give final approval tonight based on there being no feedback? Mr. Vedder, do you have a preference for which way we go on that? I'm not saying we're done talking about the application, but if this is going to be one of the things, would you prefer we just come back and then
I think that would be
Is it
easy.
February?
If we're gonna send notification letters out, then I think it would make sense to come back to the board next month.
having another official hearing
Correct,
and then finish it then? Okay.
correct.
So what other concerns do we
Because
have
that
on
allows
this?
other people that might get the notification too.
Yep. So anybody can come to that
Say
hearing
something if they
and
wish.
if they've got any issues. So do we have anything else we want to discuss about this application tonight? Any further requirements? I know at times we have talked about, do you need additional riprap, things like that at that discharge point? Do we need to talk about that tonight?
Yeah, I didn't see an easement with the new application, where the new location is. We're still crossing a road.
You have the township,
It's flowing into.
It's
an
flowing-
Existing easement
yep, so there's a culvert there.
through Langston's, right?
Well, it goes under a road.
But there's already an easement.
Yeah, is there?
There's existing tile already running there.
Well, anytime you add any kind of water, that should be discussed with the township.
Are you talking about tile or,
He's adding water from the
Yes,
stock
he's
dam
adding
going
water
south
to
through the
this,
road.
yeah.
right, so all the flow is gonna flow through the township's culvert.
Yes, I think township.
So are
should
you
be
looking for a
consulted.
township easement for
Yes,
that?
Yes.
Thought that was in here.
The one coming south, through the road.
Did you see it in there,
No, I
David?
did not see that.
Mm,
Signed by and Bob Hoppe. In my packet, it must be about 3,
Cross, this is for Road 443
299.
between, yes.
We have the easement from 2014.
I think there should be a new easement that you're adding water to.
This is an easement signed in August 19 of 2013 by Art Cease, Township Board Representative, Drainage applicant John Gunderson, and Drainage applicant Larry Linkstead, and that's from 13, and you see the one presently. So there wasn't an easement in place, and as easements go, they go with the land and they're permanent.
Is the,
You
does the
modified it.
easement state if there's more water, if there's more done, they needed more? Or it's
It says exactly,
the
Wellstown
size of
Township.
an outlet is,
It says the impact of sustained flow. All erosion issues must be mitigated with appropriate action by the applicant, including sufficient riprap to protect the right-of-way culvert and monitoring the long-term effects of consistent tile drainage in the right-of-way area.
so that would, in my mind, that would satisfy that as far as if there's damage to the road, that easement still says they need to take care of it.
That they're
If
responsible.
there's any,
If there's any more.
it would have been nice to see something from the township acknowledging the fact that there is additional water and that there is a culvert sufficient to handle it and riprap and so forth. Is
Yeah.
adequate.
And that probably wouldn't be that hard to do if we had to.
Okay, so that's two things, notification letters and update your easement for that. Anything else? Frank or?
This is Frank here. Quick question, Sherry, or any of you. Was there letters sent out for tonight's meeting?
And that was a no, correct? No, there weren't. That's why we're going to do, let's
Okay,
have one more meeting.
yep, that's fine.
Yeah.
Yep, I think that's smart. Okay, I just wanted to clarify if it was the old application or if we're talking about tonight's application. So, okay, thanks.
Dylan, did you have anything you want to add?
nope, I think everything my concerns were discussed and gone over, so no.
All right, thank you.
Yep.
Craig, are you good?
I'm good.
Okay. And Dan? Kevin, okay. So at this time, we're not going to take action tonight, but we'll see you at the end of February. Thank you.
Sherry, do we have to vote on this to table it or extend it till next meeting? Frank Krolichek.
Yep, you want to vote to table it? Okay, so I need a motion to table the GHGAS Farms application.
I move to table this.
I'll make a motion. Do we want to table it or continue it?
I'll probably continue. Yep, so
I'll make that motion to continue it.
you want a second then, Dan?
I'll second it.
So I got a motion by Krylicek and a second by Dan to continue this application to the next meeting. All in favor, say aye.
All right.
Aye.
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 All opposed, nay. Motion carries. We are continuing. So next application is for Mr. Larry Linkstead. Let's see, this is,
I was getting a draining permit to drain my section 10 southeast quarter to 10 forward across John's, what we were just talking about. And I have an easement from John to put it in that dam of his, which I did in 13. I got one in there, except it's down a little further where his irrigator runs across it. That's what he doesn't like. So we went up past his pivot and put it in so his pivot don't run through the water. And that goes over to my stock field, my water well. That's what I was looking for. And they did come in and put the tile across John's when they were there doing his. They called me on a Saturday morning. I had surgery, shoulder. I didn't know nothing about it. I said, go ahead, I'll be down Monday morning. I got all my other paperwork done. But I needed a permit, so I went down Tuesday morning to get my permit. I couldn't make it on Monday. And then they told me, well, I can't do it because of John deal. So that's where I'm sitting.
So you put the tile in before you got the permit.
They put it in because they were pulling out on Monday and they were gonna stick around, otherwise I wouldn't get it put in. And they were doing it because it was easy for them to put mine in while they were there, so it didn't interfere with his. So they put mine in first. Bypass all that. That's what they did.
We've had that scenario before more than once where, yeah, the tile guys there, they want to add a line. And
They called me Monday morning or Saturday morning.
unfortunately, what we've done in the past is we've always made them go to the.
And I had
the
everything
board.
done on the ground to
You know,
tile
that's-
anyway.
That's the precedent that we've had.
But I
Mr. Gunnarsson himself has been the one that's probably advocated that more than anyone, that everything go through the board.
But all I was going to get my permit was all I had to need from them.
So your quarter is in section 10,
Yes, yeah,
right to the east of,
east side.
so yours outletted into
John's,
which
John's.
is
that he
into
was
the-
showing
into
there,
the dam there.
which that runs through the culvert and into mine, by the way. My old one is up,
I see.
because I tiled some of it. 13.
So you tiled it, you added more tile
Another 2.
to that.
Yeah.
Frank or Dylan, do you have any questions?
No,
This is Frank here. I have no questions.
no.
Any other questions? Anyone care to make a public comment? Okay, public comments closed.
Sherry, I do have one question. Since John didn't give notice out for tonight's meeting, did Larry give notice out tonight?
Did you send any notices? No, he's shaking his head no.
Feel I didn't have to, and I was going straight crossing into mine.
So is it another, the board can say yes or no, but is it another situation that we need to have letters sent out? And if nobody comments in 10 days, that the permit is granted if we move forward?
I think under the way we originally were doing them, that you would have sent letters because you are crossing parcels and easements involved. So maybe to make this
But it don't,
consistent,
it don't concern no one else.
right, so nobody should complain, so it would
Just
just be a
between
notification that
me and
that's happening.
Hmm.
I know upstream, which maybe, I don't know if the,
But it all goes
maybe
into my,
the letters are just to yourself, I don't know.
but it goes into my, it goes into my dam, that's where.
We probably should have one from the township too, being your water's gonna go through that same culvert with John's.
So we've had that done already. I already got water that goes through there already.
I know, but, you know,
I
mirroring
think
what John
his
had.
easement with John, that dumps into your pipe up above the dugout? Or does your pipe outlet into,
Mine dumps,
Connects.
runs little, the dam there, and then it runs.
so it's got a separate outlet into there? Okay.
You know, it goes through the same culvert on the road, big culvert. Which it's a big culvert. I've only seen water go over that road once, and that's when it gets 4.5, 5 inches of rain. Right? Nothing's gonna stop it.
So
And
I just want to clarify where it dumps there, that has always emptied there. You've always had a tile line empty there. You're just
Back in
adding
13,
on.
I had one, no. When I put in there small, it won't handle what I want to do.
Okay,
So I put a 12 in.
so you're upsizing.
Father foot came up in there, so it's on this side of it now.
Gotcha. So it is a change in drain size. So I've heard a request to send letters out, very similar to what we're asking Mr. Gunderson to do. Are we asking Mr. Linkstead to then come back for a formal hearing again in February?
Now, are you changing the amount of water you're putting under the road through that culvert?
He's upsizing his drain
Yeah, I'm
outlet.
putting a 12-inch.
Yeah.
The drain outlet is changing.
We asked John to get an revised easement from the township, which sounds pretty simple.
But that's the same size culvert going in there that comes out of my dam out through the other outlet. So, I mean, that's a big culvert. So what comes in is gonna go out the other side by the other road, and it's never ran across the road on the other side through my dam.
So I think what Mr. Grant is stating is we're asking Mr. Gunderson to update his easement so the township's aware. And I think he's probably trying to keep it similar in request, that you alert your township, say, we're upsizing the drain.
Yeah, I think if you would have come to get the permit prior to doing it, it would have been a notification and just make sure that copy of the easement that you already have in place, so.
From the township.
From the township and from John, between you and John. And that might be in
And
the
I already
packet.
have
The original
his.
one is in there, I think, so. That's already in there.
So just get one from the township.
An updated
Yeah, I
one.
don't know if it can, both of you be on the same easement with the township. Maybe the first easement, I'm not sure what that, yeah, it's for,
We can spring for an extra sheet.
There you go.
I think that budget.
So
Okay.
I can just take it to the zoning deal when I get it.
Oh,
think
the
if-
easement?
Yeah.
Yes.
yes.
Yeah, give it to the zoning
And
office.
then if we want to have it come back the same with John's, I'm whatever you think.
Yeah, so probably the best is to reschedule this one. We'll continue this and we'll handle this at the end of February, exactly like
We'll
we're
get you
doing
the
for Mr. Gunderson.
List the names that the letters need to be sent to, which probably isn't very many.
It's probably almost exactly the same list that Mr. Gunderson's going to have on his.
Okay,
Okay,
thank you.
you're welcome. Frank or Dylan, did you have any comments there?
Oh,
I'll just make a motion. Frank Kralchek here. I'll make a motion to continue Larry's with, I heard, if I'm correct, hearing, township easement added and then letters sent out with
Yes.
notification.
That's correct.
I'd
I'll
second.
go ahead and make,
Just tap.
Yep, I have a motion by Frank, second by Dylan, to continue this to the next meeting with the request that letters are sent out for the official hearing and an updated easement from the township is obtained. Further discussion? All in favor say aye.
aye.
All opposed, nay. Motion carries. Would anyone care to make a public comment at this time?
Sherry, this is Frank Kralchek here. My
Yep.
question is, since we got notice and we were having this hearing, and maybe Gary can, veteran stuff can answer this, and we knew these applications were going out, how come there wasn't letters sent out to adjoining land? Have we changed our policy at all, or what was the reasoning for that? Because this could have been all solved this week or tonight
Right.
instead of next month.
So you heard the reason for the first one. Basically that we didn't send out because my interpretation was it was going on to his property, from his property. So there wasn't letters sent out there. The second one was more of a timing thing. By the time he came in and requested the permit, we were already notified that there was questions and they would have had to come to a meeting regardless. And so then the letters just weren't sent out at that point, once we got notice that he was going to have to come to a meeting to discuss it.
But Gary, I don't want to, but we got our packets and stuff.
I certainly
This
agree.
is-
We could have still had him send the letters after that notification and all that correspondence between the state's attorney and things. We could have sent those out and we probably should have.
Thank you.
Come on up, Ray.
Ray up Mission Hill. I have no discrepancy of stating that I am severely confused this evening. You know, listening, it was hard for me to listen to this because one applicant had a procedure out and he had correspondence to change it. And he came and he made he let people know in the action what was going on, kept people up to pace. I appreciate the fact that all he has to do is send out notification letters and things. And, you know, being on a township board, I appreciate the idea of notifying that more capacity, because after having to deal with FEMA, I never want to deal with them again. But anyhow, I appreciated those. And then the second applicant came in here. There was no discrepancy on the procedures done. It was lack of protocol, so to speak, in policy. One had the okay, he did what was, to me, sounded right. The applicant did what seemed what was right. But I remember sitting back there, and if you increase water capacity, you do have to send out notices. So, and you are requesting that. It's hard in the state of our nation right now with procedure and protocol to, you gotta stick to one gun and universal. I'm hoping you don't come get me for saying that, but I hope you know what I mean. Procedure and protocol is so important. I appreciate the conversation, but hopefully that can be reinforced down the line a little bit further. Thank you.
Thanks, Ray. Anyone else care to make a public comment? All right, public comment is closed. So we do have it on the agenda to start discussing possible ordinance changes. And hopefully everyone had a chance to reread our ordinance. It's not overly long. It is interesting. The first part, I guess, I don't know if the first part got sent out to everybody, the introduction part, but the articles themselves. So I took what was sent out in our mailed packet and I reread it, just blind. And then I made notes on it. And then I pulled out this working copy that I've had the last 2 years that I've sat on this commission with the notes that we have made and I've written down of things that we said, maybe we should change that. And it's interesting how they're kind of different. When you reread an ordinance after you've used it for a while, you make a little bit different comments. So, you know, and at this point, I think it's to Ray's point of, it's important to have a procedure and to stick to the procedure. And sometimes when your procedure isn't very clear, it's hard to stick to that procedure. And I know there's a lot of different interpretation when you read the section we were just talking about. And that was section, now, why am I not? Here it is, section 305, especially under administrative permits. You can read those two and you can read those two. And I bet you if you had 10 people, half of them would have one interpretation, half would have another. Maybe it would be 3 and 3 and 4, how you walk away from that. So I think, and I guess what I'm trying to get to is, I think when we get done reviewing this ordinance, the biggest goal for me is to make it very clear exactly what Mr. Vetter's authority is, what this commission's authority is, and what the drainage board's requirements are. Because everybody has a little bit of different interpretation on what levels those should be, if you're understanding where I'm going. I'm not communicating very well tonight. I apologize for that. So I think one of my goals is to clear that up. The other goal is to decide overall what drainage do we want to oversee in the county. We've got tile drainage, we've got surface drainage and ag application. We've got folks who move outside the city and build homes amongst each other, and pretty soon they're draining water on each other between 2-acre parcels. And how our ordinance is written today, we could say we have authority to go in there and do that. We could say we don't have the authority to go in and do it because we have never taken that authority. So I think that's another thing we as a commission probably need to discuss, where we want to end up with our authority. And then there's some minor things in there to talk about. Mr. Gunderson had mentioned a change of 10%. Well, what's 10%? 10% feet, 10% miles? Is it distance from what? I mean, if you got a drain here and you move it there, it's 10 feet, but 10 feet compared to what? So things like that probably need to be cleared up, but those are, to me, toward the end of the conversation when you go through. I think the theory of drainage itself, we probably need to revisit from a 10,000 foot view, if you will. So I've spoken a lot. I tend to do that. So I should probably be quiet and let other folks speak with your ideas of where you see a drainage ordinance review going.
Well, then we still have drains that are non-compliant that are draining out into the ditch. I know it's several years ago when Pat sent out, well, 50 violations. And I think he got around 34. He told me the voluntary compliance when he started a registered letter. And, you know, I got 2 of them within a half a mile of me that have never corrected or never, you know, and they got notified too. And, but we as this board have no authority, you know, to,
They were done prior to also, weren't they? The,
yes, but they were still done illegally into the ditch, which is not our, you know, it's under state statute, so.
right.
So it needs to be our state's attorney or our county going after it. You know, that's where Pat sent those people letters and they complied. So how do we go back and address those issues too? Cause it's more than just, you know, right next to me, there's other places that are the same way.
Oh, I think Craig, Frank Krolichek here. That was Craig, right?
Yeah.
That was speaking. I think prior to us doing the drainage deal, all we had to do is go down to the county office or county road superintendent, and he just granted us permission if we could drain in a ditch to the culvert or whatever, and they just said yes or no, and nobody did anything that I know in the past prior to our drainage board, because there's quite a few, like you said, there's quite a few of them out there that were that way. We went down back then with Sorensen's and made sure it was okay with them and went through the culvert and right to the blue lines and things like that. And you're right. And correct me if I'm wrong, I think the flow of the water under state law, as long as you're not changing the flow of the water, there shouldn't be a problem under state law.
Yeah,
The direction of it. You know, you can tile, and then if it's still going the same direction, you're going the same blue line and everything like that. The state law says that's all right.
yeah, I'd have to go back and look at the statutes.
Even
And the only
years past township.
this is Frank. Go ahead, Kevin.
In the years past, townships were the same way. I think if a couple of guys were going to drain a field, needed to run it down the ditch. If the township gave approval, it was just wasn't even written. It was just an oral approval that yeah, it's okay.
Yeah.
So a lot of them were put in at the time they were allowed. It doesn't right or wrong. And I don't know that this board or anybody can do anything about it now.
Yeah, well, I got a permit this past year. It got dry enough and now I got solid pipe running through my field so I can pick that water up and run it through the underneath this. It was trying to cut a new trail across my hay meadow.
And then a lot of them ditches that were put in, they had a chance to invest them, so they're coming right. Farmers, the field ditches are coming in. Township ditches, but they were vested because they were allowed to do that until whatever year, 1985. Or
Yeah,
they
back prior to
stopped
85.
the.
So I've gotten my problem fixed now, or we hope we have it fixed, but, or at least lightened up.
But I think the intent of the board when we sat on it, developing it, was agricultural drainage tile, because there was a lot of tile starting to get put in. And it was to protect the rights of those putting it in and the rights of those that lived around it.
Yeah.
Just to notify that people would be notified that something's happening and that they have, the water needs to get somewhere where it can drain, not just be dumped onto another person's property and create problems. So give a place for a lot of issues get solved before they got. It allowed people a place to visit about that and say, this isn't gonna work, or it is gonna work.
Yeah, so we didn't have another Hutchinson County incident.
Yeah, and that's kind of where, otherwise, if you have no drainage board, then you end up, it ends up with the county commissioners. And at that time, they didn't have time to deal with all the drainage
Nor the knowledge.
that come
Usually.
to them, in a meeting. Because that one drainage permit could take up more time than a lot of their meetings, so. And I don't know that I agree with everything the way we're doing it exactly.
What would you change?
And I don't know what the rule is on the easements between parcels, but I know we did that because parcel numbers are recorded separately at the courthouse. So that's the reason we started, I don't know if we started it right away or in there somewhere we decided that because people, maybe land gets split up down the road. That's why, now whether that has to be here, I don't know. Personally, if them easements were done to the zoning administrator, then that, if it's, as long as it's part of that permit and it's granted to themselves or they have the permits, the easements between themselves, I don't know that it needs to come to the board for approval.
So you're
As long as it's part of the permitting.
okay, so you're talking if I own two parcels and I'm draining from parcel A to parcel B, but I own them both and I give myself an easement, Mr. Vetter, as the zoning administrator, should be able to approve that project
Yeah, I think so.
without
But I
it
think
being
that-
reviewed.
That needs to be clarified.
So that
in the
needs to be-
ordinance because
But you still list the parcel numbers because now you up and pass away and you have
Yes.
2 children and they each get that 80 acres.
Yes. And they don't like each other.
Yeah.
right, that was the purpose
Okay.
of it.
Yeah.
So a self-draining to self is essentially a zoning administrator approval.
Now, if it's a project that involves notification of others within the half-mile upstream and a mile downstream, then I think then people need a place to be able to comment if there's an issue with the permit.
You know,
So do they, if those need to come before the board? I think that was some issues that we've had off and on.
so here
If
as,
nobody complains, then maybe a meeting doesn't need to be scheduled, but if somebody does, then they have the right to a meeting.
okay, so I'm going to read a couple definitions that, and I think I marked them on the other one, stream. Okay, so when you go and you look at the definition of stream, intermittent and permanent, they're the same definition. There's one word that's different. But essentially they're the same definition. And then when you go to that 305, it says into a permanent or intermittent stream. So right there, you know, as an example, let's use Mr. Gunderson's. You know, it's fresh in our minds. We've got a blue line and we've got, I would guess, is it 200, 250 yards? I don't know. Quarter mile would be 440 and I don't think it's a quarter mile. So I'd say half of that, say it's 200 yards to get from where he is on his property and it's going to drain to that blue line. So is that the intermittent part? Is these little fingers that go into the blue line, which is the permanent stream? So do you see where I'm getting with that is how close, do we have to be in the blue line or what's an intermittent stream?
Back when they were doing that blue line study,
Yeah.
where they come up with all those maps, there's actually some dry fields that have nothing more than about like a plowed furrow
Mhm.
running through them. That yes, in an extremely wet year like we've had the previous 2 years to this year, yeah, there was probably water in that little.
Well, and
trench.
it also has to be a blue line that has enough drop and enough capacity to take the water too. Because like you say, some of them are in the middle of the field that don't have capacity.
Cause they had those little, like a paddle wheel that turned with the water flow to see how to sustain so much water flow for X period of time to come up with whether it was considered a blue line or an intermittent stream.
Okay. So I think we can look at that definition itself, but when you look at the administrative permits, for the most part, and I think part two is there is a thing, a permit may be issued if no abutting landowner files a written objection within 10 days after the mailing date stated on the affidavit of mailing. And that was your point, was if nobody has a problem, it shouldn't have to come to our board.
Yeah, as long as they have a way to file an objection
Right,
to the zoning administrator.
right.
I think it needs to be really clear in the letters too, that,
That they, if they
Why
don't
did they-
act, it's automatic.
yeah.
Essentially, that's what
yes,
we're
if they
saying.
don't act.
Okay, so, because that second one reads, a proposed drainage project which outlets directly into a permanent or intermittent stream. And that means that pipe has got to be in that blue stream. Are we all in agreement with that interpretation?
Well, that's how we've interpreted it in the past.
You mean that it-
Tonight it seems to get a little
Do you want to repeat that again?
vague, I guess.
So a proposed drainage project which outlets directly into a permanent or intermittent stream, not listed in number one above.
So Sherry, Frank Krawczyk here.
Yep.
My understanding, you're talking intermittent, that's not considered blue line. So like Chad Islands we had in December or November, his ended up in the blue line. There's a defined ditch going to that blue line. Would you consider that them be able to permit?
Well, that's what we're looking for clarification on, is because whenever we're all sitting here and we're not sure, maybe, you know, the public isn't sure.
That's the reason I'm bringing this question up, because Chad Islands is fresh in my mind. We just did it.
Mhm.
He proved that he had the drop in the flow, but the blue line was down the creek or down the draw further where they drew it in. So if I'm interpreting what you're saying is he can almost got his permit by saying intermittent or whatever. He could want that route. Am I hearing you wrong or thinking wrong? Just let me know.
Well, and that's why when I went to the definition section, and the definition of intermittent is the same as permanent.
Yeah, I think that's what we're trying to
You know,
decipher,
so
determine.
we've got some, come on up, John.
I know why that's in there.
Okay,
That is a discussion, that's a remnant of a discussion between Pat Garrity and I back when the ordinance was being drafted. And I'm going to pick on myself again. Let's assume Larry and I were having this discussion and say there wasn't a road, but say we were just dealing with two quarters and we were in agreement and it was obvious natural waterway that wasn't on the blue line map, we authorize the administrator to say, yeah, it's not a blue line on the USGS map, but it's 20 feet deep and it's a natural waterway. Now, our case is different. We have the road, got no problem with that. But this, the blue line that runs up through Larry's stock dam is a crazy line because it runs from the culvert up through the dam, up across his quarter and 100 yards into the neighbor's field to the east that is as flat as a pancake. But where it's 20 feet deep and runs into me, it's not.
Mhm.
It's just one of those, there's obviously an intermittent stream.
So are you saying the word intermittent was put in there for interpretation,
Yeah,
even though they didn't give it a good definition?
even though they didn't give it a good definition. But it did give the administrator the right to issue the permit in a clear-cut case. I'm not saying ours is, this is, keep mine out of it. But it did offer him to do that. That being, period, new paragraph. Pat almost always brought anything like that to the board, just in case. Because when we were starting this out, everything was, we have to write the rules as we go until we get the procedures done. But it's in there to grant the administrator that power. It has been used rarely. So I hope that clarifies.
Okay.
Okay.
And I would agree in the past, a lot of them, I know of a few of the permits that would come where they went to the culvert on their side of the road, then it ran under the culvert through a ravine to the blue line. But then they also got an easement from the next landowner, if that wasn't their land, to allow it to flow through there till it got to the blue line.
And probably the
So
township
that was part,
or
and
road
from the
authority.
township that it's okay to run on the road and also
Okay.
through that.
You know, but even
But
in,
that could be done administratively if all the easements are in place.
okay, letters still need to be sent out.
In that
Yeah.
case, letters would have. to
And
be
if there's
sent
an,
out, right.
and if there's an issue with anybody who receives a letter, a hearing is held.
And agreed, please keep my situation out of it.
Well, I think Chad Eiler's one was a good example. It's very similar because he crossed a roadway and he was trying to get an easement from GF and P.
And they said no.
Yes.
Now, you say how much, just throw a number at me, what would be a percentage of that Pat just okayed it with the intermittent?
Very few,
Very few, I think.
very, very few.
So it's
Zero.
he
Just
was-
about all of them came to the.
Oh,
board
yeah.
at that time.
Yeah.
So going off of that,
I want to try and answer Dan's question very carefully. Pat felt that he was an administrator. He was not an advisor. And if there was any doubt at all, he would just bring it to the board. And again, back 7 years ago, when we would have some of these hearings, we'd be stacked up out into the hall. But until we got these procedures worked out, and then he granted a few, not very many. I don't know how many, I don't remember. Pat, I did talk to Pat before coming in tonight to make sure that what I understood from the ordinance was, somewhat kosher. Call me ultra reformed at least. And, he was, he did that before. He didn't do it very often. And he recognized it. There's a South Dakota Supreme Court case that says all drainage cases are unique. And Pat recognized that, and I think we all do. So, and that's why you're here, because you've got to come up with everybody as special and unique.
I guess with that line of thinking, why put an extra burden onto somebody that may or may not agree with the person that comes in after him or that was before them? Why not make it clear that it either goes into the blue line or comes this way, you know? Don't give it the interpretation on it, because that's where you can get in trouble.
And I agree, and that's why I certainly appreciate clarification on some of those details like that. And, you know, we talked about why letters weren't sent out and things. You know, in this particular case, when the permit was requested basically after the fact, and then, you know, I think that was the point that we assumed, I guess, that we weren't going to send out letters because the project was already done. So maybe we need to clarify some of that procedure also of what happens and what are the consequences of things happening after the fact.
Yeah, in the past, that'd been a clear violation. So I'm not following the ordinance. I guess that's the point. I'm not sure why we're diverting from that past. Anybody have any comment on?
What was the ramification of this prior too? Because we had other ones that came in, that projects were completely done with no permit.
Yeah,
And then the
typically
permit
they
was
were,
given after the fact, so.
yeah, typically there was fines involved is what we've done.
I don't remember what the fines were though, because see, that was handled by the.
No, we've had them here before, yeah. There's typically a fine issued.
I think a good example, Frank Kralchik, was the Schmidt one that was done, and then it came back to us after it was done.
Was there a fine on that one? I don't remember.
Is that on the lateral one? Was that on lateral one, Frank?
Yeah, it was down there by Steve Schmidt's ground. They did one quarter, and then they went ahead and tiled the other quarter that wasn't permitted, and then they went ahead and then it came back to us.
Yeah, and
Then we had to put a valve on, and it pumped water, and that was going back on Ray Epps fields because they were pumping all that water and stuff.
right.
So I think we fined him on that, or the board did, or the commissioners did when it was all said and done. I'm not 100% sure.
We recommended, I believe, $500 fine, and I believe the county commissioners went $1,500 fine, and they fined the installer too, because he was from Kansas.
And just a quick FYI, Eilers will be back in February also, so that, because they did get approval from the state now. So we'll be hearing that one again next month.
Well, good. 'Cause there was nothing wrong with that. That whole project, you know.
Yeah.
It was actually improving the situation for the state. Filtering the water, slowing it down, metering it out.
I think the big thing is consistency.
Well, that's, I'm trying to, yeah, that's
On
exactly
any
what I'm
of
trying to
these.
say here, right? In fact, that's how the county gets in trouble.
Everything's
We show-
unique, but yet needs to be consistent.
We show favorism for one person and fine another. That's when counties get in trouble.
The word abut in this definition, all landowners having land abutting the proposed drainage project for at least 1/2 mile above and 1 below. And I know I recall discussing, is it the land that abuts the quarter that you're draining, or is it the land that abuts the stream you're draining into? Because to the north of a project that's draining south, should that notification go out?
We
that
generally
way?
did that so that so it give them an opportunity
To join
discuss-
in.
To join in, because
Okay.
sometimes it happens and they never knew it was gonna happen. And it gives them an opportunity to have a discussion that, hey, there's a project going downstream, because a lot of times the lower landowner is the one where the blue line is,
Mhm.
and the ones upstream can't get there
Right,
without that.
okay,
And
So
could
that's the
make it-
reason we did that.
And that could make a difference on the main line tile size coming down through
Right,
it.
it changes the whole project. Once it's in process, then the upstream landowner said, well, I could have drained mine in too, can I now? Well, then it changes the size of the tile outlets potentially, or the amount of water flow adding to the project, so.
okay. I just wanted to
And then
clarify that.
I think we always assumed that it was the down, not the parcels on either side of the project, but the ones that are around the blue line going downstream, I should say.
Okay, so that's
A mile.
essentially saying a half a mile around the parcel and a mile along the stream. You see where I'm kind of getting that? I just wanted, again, the more you clarify,
So
the less
your
questions there are.
understanding is a half mile on either side of the stream and above it, and then a mile below.
Well, I'm
Or,
just
mean, is that what you're?
trying to interpret, so if I've got a quarter I want to drain, and I'm gonna give notification for the half a mile around there for anybody who wants to tie in, and then if I'm going to dump into this blue line, and it's gonna affect the mile downstream. So these landowners are gonna be affected by the water I'm dumping on them.
Mhm.
These landowners might be wanting to dump more on them and join. So you see where I'm kind of getting with trying to be consistent in who we're requiring gets a notification. Because one project might say, well, I only went a mile, half mile up the stream, not a half mile around my parcel. Well,
Yeah,
I mean, and then someone comes in and said, well, I didn't get notification. Why didn't I get notification?
Typically, Pat went from the outlet,
The outlet point,
the outlet.
half
point.
mile, half
Drew a
down,
radius, half mile up,
half mile down.
mile down.
Okay,
Yeah, because if we were outlet,
Yeah, but this is Frank Kralachek here. But the half mile up, you know, I know McGinnis, when we were doing our big project, was struggling with that whole comment. If you go a half mile up from the outlet of our Heine Kralachek project, it was miles from the outlet where the last tile went into, or at least a mile and 3/4 upstream. So that's the only problem with the outlet going up. Say I own a quarter, a half mile is a quarter. You don't have it. The next neighbor to know that you're tiling up against him. I think notification to people upstream is very important because there's been many projects that have had connection to or connected projects together.
yes.
Mr. Healy, you talked about half mile up from the outlet. Does that mean that I don't need to send a notification to you and ours? Because it's 3,400 feet from our outlet up to the corner where your property is.
Yeah, I'd have to read that
Half
again.
mile would be 2,600 feet.
That's what the ordinance
right, if
says.
the outlets are down on the bottom end of a property, then,
That's what you run into now.
right.
So I don't hear an answer to my question.
I'd have to verify your measurements there, Mr. Gunderson.
For sake of argument.
A quarter mile is typically a half mile. You know, a quarter section is a half mile, and I'm a quarter, you know, up north of you, so that would be a half a mile.
Southwest, the outlet is the southwest corner. So, 1.42414 times 2640 works out to about 3466. If I remember right.
The hypotenuse.
So your point being,
We shouldn't have to send you a letter then.
that's right,
Send
okay.
you a letter or not.
In the, if your measurements are correct, you would be correct according to the ordinance. Are you gonna follow the ordinance or not, though?
Well, I don't know if the
All right.
ordinance states from the
You're
outlet.
talking half mile from the
Does
outlet.
it?
he's talking
That's
about-
typically
I
we
think
win
it's
a
a
half mile.
Proposed outlet is what
From
the
the
ordinance
proposed.
says, proposed outlet.
Right, typically it was the outlet.
And my question is, do we want to keep that or change that? So that people, if you like, and again, if your outlet's down here to the south and you own this whole quarter, that's a half mile, nobody to the north of you knows what you're doing. Because technically you're outside the circle.
That's
You see where I'm getting
Yeah.
at?
I will
That's
say
what it says today.
the letters prior to though were sent to abutting properties.
And I think abutting properties as well.
I'm just gonna, there's one on Highway 46 that was tiled. The outlet was by Highway 46.
Mhm.
So that was the outlet, but a mile, probably a half a mile, and then to the south and to the east, the property owners were here because they were notified of the tiling project, although they were well over a half a mile from the outlet. They were probably 3/4 miles, almost a mile, but they were notified, and then that gave them an opportunity to look at the project. But so that, and I know in that case, it was abutting properties.
Right,
Right.
right.
And I agree with that. I'm just saying, technically, if you read the letter of the ordinance, that's not really what it's saying. Yes, sir.
Someone who's gonna be sending out letters next year, so I'd say, but.
I mean, and it's always, more letters is better to send out than not enough letters. It always.
Abutting
is.
properties gives a farther
Right.
reach to people.
And gives a
that might be
clear
interested in
cut-
what's going on.
Assignment to what you're sending out to.
That's
No,
good,
that's
but I don't know
clear cut.
where
Yes.
Mr. Vedder is gonna agree with that, because 9 times out of 10, the calls that Pat Garrity would get were from some lady out in California who owned the property, got a letter, and didn't have any idea what was going on. So that's,
But they
That's
still
gonna
have a right
take
to
their
be,
time.
they still have a right to be notified.
They
you know, yeah, I'm not saying that. I'm
Yeah,
just
no,
saying
I
that that's
agree.
gonna
That
create,
is the tough part of it
you
because,
know,
we do have a lot of out-of-state
yes. you're gonna get a
owners
lot of
and,
calls.
so you do get calls that ask, but that's, I don't know, that's not a problem. I don't feel for us either. It's-
We do too, as
We have no issue talking to them about what's
It's
going on with the
Explaining
project,
what's going on,
so.
right?
and as an operator of, sometimes we've gotten calls from landlords.
Well, I'm sure you
saying,
have, right.
Say, I got a letter for this
Right,
project.
I got a letter.
And I wouldn't have known about it, other than it was through them, and
And that, and typically the first call would be to the operator.
Yeah. to clarify what's going on.
Right, right.
So would you suggest, if we would agree on that, you would change that in the ordinance, that wording,
Yeah, I think I'd
so that it would be,
be pretty clear that land,
so would you go abutting on all directions?
if it was me,
Make
I'd
it
go on
clear cut.
Side. to
all
s-
directions, whatever, or you just say whatever, all abutting property
Well, I
has
think
been.
half mile out, just say abutting property.
You don't have to go a mile downstream and just
You know.
do abutting properties.
Well, but should you go a mile downstream because they're the ones taking the water?
They also don't have, you're reaching the Blue Street on your property line. They don't have the right to stop.
Right, that one they don't, but if
Notification,
I'm draining onto your blue line,
but if it's coming from the blue line on your side, I can stop.
no, but if you've
Right.
got the blue line. And I
Then-
want to drain
then
onto
you
your,
have to come get an easement to get to.
from you, but do the landowners a mile downstream need to be notified of that?
We've done in the past. I would want to know, because I may want to put
Yeah.
a
who may-
tile in myself,
Yeah,
Say, hey, that,
you know.
water ordinance.
Right.
Done with it, then at least it gives them.
Or it would become part of this project.
Sherry, this is Frank Karlchek.
Yep, go ahead.
I'd say go down the mile down the blue line. For example, it would be the Nelson and lift drainage tile we had last year, or maybe that's been 2 years ago, where Lith was notified that Nelson's and all those guys were tiling on him. Then he came in and talked. We still granted the permit, but I think it was a notification, and they tried to work out stuff to make sure the water flowed and stuff. So I think going downstream is important, especially in certain situations like that.
Yep.
That was a permit that was given administratively. But because of the letters, it brought it to the board then because it created a
Just long discussion.
And a long discussion.
Long discussion.
And eventually it got worked out, but it did give them a
Okay.
place to do it.
Yeah.
Yeah,
There's
Jake.
another situation where I know in the county, the blue line comes down, it disappears for a quarter to half a mile, and it starts back up again. So you need to make sure you got that full mile, just, 'cause that guy where it disappears, yeah, you need the line to go all the way through. So,
Okay. Jay's comment was sometimes there's a blue line that disappears and then reappears. If you guys at home didn't hear that. We have to be cognizant of that as well. Okay, well, we're pushing up on 9 o'clock and I certainly don't want to keep anybody here really late. If you guys have any comments further, you're welcome to email them to me. And I'll try to maybe work up some wording for some of the stuff we discussed tonight. And one thing I want you to walk away thinking about is the county commission moved the planning commission to 7 members. And there is a request to move this commission from 9 to 7 as well. And what that does is every year 2 people are up. And then you have 1 county commissioner on the drainage commission. This is not the drainage board, the drainage commission. So give that some thought. And at our next meeting, we can continue talking about some of these, but I do encourage you to go through and read some of this stuff. And the other thing to consider is that 10% deal. And that gets into
Yeah, that's totally vague there.
3.03, which is the actual application, and look at what the application is supposed to be about, because there's A through H listed there. And if anything has changed in the last 8 years, since this has been approved, that we need to update, or maybe it doesn't make sense to have it in there anymore, because over the years, we just haven't felt it worthy. So give some of that stuff some thought. That was the application section, which is 303.
Well, when this ordinance was originally put together, the thinking and the thought was that, yeah, it's probably not perfect, but it's something to start with, and that it would be used for a number of years and then readdress some of these issues. And so I
Yep.
think it's very good that we're doing this. And I think there's certain items that need to be clarified. And like you say, the 10% is,
I don't
who
know.
knows? I think the expediency is, well, I think we found the applicants tonight.
I don't know.
Tile plow is there. How do I get a permit? In the past, you would have had to wait 30 days, maybe even more for meetings.
Yep, and I know some counties, instead of sending out letters, if you go to all your neighbors and get the sign off, say they've
Right.
signed off, and
Right.
if they can come in and say, the tile guy's here, all my neighbors have signed off.
Right.
You're gonna be asked that situation, so we need to be prepared
Right.
to answer
I
that.
think there's a situation where Gary should.
Yeah,
have
that's
authority
one
to
of
do
the
that.
issues that we've heard a number of
Yeah,
times,
that's
is
probably the
that,
biggest
well,
complaint
the
we
tile
have.
guys are all of a sudden out here and now we want to do it today, and I haven't gotten my permit, and they don't want to wait for a meeting, and just like this happened. And then it's always an after the fact thing. And that's why, like I said, we
Yeah.
need to determine how we're going to deal with the ones that just go ahead and move forward. And because there's nothing really in the ordinance that states any specific thing that occurs besides, there's mention of $1,000 fine and stuff, but that's all based on nuisance complaints and stuff kind of too. So certainly want to talk about that some more.
Yeah, well, my concern is that we don't show favoritism. And like I say, that's how counties get in trouble. You show favoritism for one person and the other guy has to jump through all the hoops to get his permit.
Something that you might want to address that kind of popped up tonight was the conflict of interest. we might want to
Well,
look at
what
that.
is conflict of interest? Maybe defining that, or how it's handled.
Well, yeah, I could say that any and every person Mr. Gunnison called before the meeting that created a conflict of interest.
So having a definite, what does it mean?
Yeah, and we struggle with that at the county commission level too. I mean, there's, like, when we discussed the tax program for buffer strips along streams, and we were considering adding a stream for eligibility, and I'm gonna benefit. So if it passed, I could go in and apply for a tax credit. And I said, no, I can't vote on that because I could be construed as gaining
And that
from
one's a
that.
little
Even though
more-
it's like $10, I'll probably save,
That one's a little more clear cut.
you know, and just, we've had some instances in the past that were a little more unclear than that. But anyway, it's 9:00. My goal is 9:00, so.
Do you have a timeline that we would like to have this finished by?
You know, I would think before
Changes
May, June time, because
After a
then,
couple more meetings?
yeah, I think
et cetera?
so.
Okay.
I think, I really do ask people to read it close and look for those things that if you were coming in, it's like, wow, that's not really clear. And if we can clear the language up, and I
So
know
then do we need to publicize that and read it twice?
we will have hearings. This is just kind of a getting going thing. We will
Okay.
have to have at least one hearing. And then it has to go to the county commission and have more hearings.
Oh,
So-
you guys have it on.
The
that.
county commission has to
We don't
approve it
have
as
to
well.
have-
Yeah, we will. We'll have a public hearing, right, Gary? Yeah, because they do at the planning commission level too for any ordinance changes. It's always better to hold the hearing and make sure you get official public comment. So we'll have not at the next meeting, probably, maybe March meeting, we can have something a little more. All right, I'd entertain a motion to adjourn.
Motion to adjourn.
Second.
I have motion and second to adjourn. All in favor, say aye.
All right.
Carries. Thanks, guys.